Start unplugging stuff.
I know, I can't figure it out. Corn fries? My lords, this challenge is, I'm now on ground one of the appeal, and this challenge is to the respondent's failure to have regard to relevant considerations in reaching its conclusion, including but not confined to its conclusion that the UK's financing of the project was compatible with the UK's obligations under the Paris Agreement, including Mozambique. So it's a challenge to its failure to consider all that it needed to reach conclusions on climate impacts and Paris compatibility. And we rely crucially on its failure to quantify Scope 3 emissions and its conflation of emissions and avoided emissions. Now, I'm going to take you to 6 facts that were found and established below. None are in dispute between the judges in the judgment below, nor are any of them disputed by the respondents. And we had very detailed submissions on the documents in the divisional court. I don't have time to take you to those documents today, but you have them all in your bundle, and you must proceed on the basis of those facts as found by the divisional court. First, the Environmental Audit Committee in 2019 said that the quantification of Scope 3 emissions was essential to assess climate change impacts of such projects, and the EAC referred to the GHG protocol as a widely used existing methodology for assessing Scope 3 emissions. At our skeleton 52, you find the relevant references. Secondly, the Scope 3 emissions of this project will dwarf Scope 1 and 2 emissions, and you find that our skeleton, paragraph 36. Third, Wood Mackenzie, the consultant, not an environmental consultant, but nonetheless, had been requested to assess Scope 3 emissions on the project, but they were not asked to use the GHG protocol. That's our skeleton 50 and 56. And Wood Mackenzie said this could not be done as the destination of the fuels was not known. That's our skeleton 48. Fourth, the failure to quantify Scope 3 emissions was heavily criticised by UKEF's internal expert environmental climate advisors, including the members of EGAC, ECAG, and by the Director General of Energy Transformation and Clean Growth at BEIS, and that's in our skeleton, paragraph 49. Fifth, the CCR undertook what UKEF described as a qualitative analysis instead, that's at 54 of our skeleton. At no stage has the respondent measured the Scope 3 emissions, nor the timescale for meeting the temperature goal, and that's at 58 and 59 of our skeleton. Sixth, when the Prime Minister requested a quantification for the purposes of CCS, one was produced within 24 hours, and you find that at our schedule 57. There's no dispute that UKEF's climate change analysis, including on the Paris Agreement, was material to the decision, my lords, and that is set out in paragraph 279 of Mrs. Justice Thornton's judgment. Being material to the decision, the conclusions on it had to have been reached rationally, not arbitrarily. In order to be reached rationally, they had to be reached on the basis of the necessary information to reach a rational conclusion. And I refer your lordships to Lord Carnworth in the OFT case, Authorities Bundle 3, tab 33, paragraph 93, and the end of paragraph 96, quoting Lord Russell. If there was inadequate material to be able to reach a conclusion on the facts, the conclusion is arbitrary. My lords, we rely on the principles in the Plantagenet case, and we've set these out in paragraph 43 of our skeleton, and there is no dispute between the parties as to that. Now, as Mrs. Justice Thornton finds, even applying a considerable margin of discretion to the decision maker, it was not reasonable to proceed as UKEF did, particularly without a quantification of scope 3. We say that Mrs. Justice Thornton was wholly correct in her analysis, and we rely on everything she says from paragraphs 279 to 325, and crucially from 329 to 335. Notably, the respondents have failed in their skeleton argument to deal at all with what she has said, save incorrectly to say that to uphold it would go beyond expert advice, and they say that in 2.3 and 61.4 of the skeleton. And we have dealt with that at paragraph 28 of our supplementary skeleton. It refers, the respondents have referred to the wrong expert advice. The expert advice was that Wood Mackenzie didn't provide a basis for assessment, even of impacts. And the CCR, moreover, produced by UKEF, went beyond Wood Mackenzie. I'm afraid, my lords, you're going to have to consider Wood Mackenzie in your own time, but we urge on you the reading of Mrs. Justice Thornton. Wood Mackenzie had been wrong to say that greenhouse gas scope 3s could not be calculated. They plainly could, and the GHG protocol was a basic way to do so. As you saw in that email I took you to this morning, another method is the Jukes method, which was the one used by Bayes when they calculated the figures for the Prime Minister. The internal expert advice in UKEF was that the failure to quantify scope 3 was a big gap in the analysis, and that is largely set out by Mrs. Justice Thornton. And the ambiguity and uncertainty in the respondents' position on the emission impact of the project is sufficient to reveal that. The use of net reduction when they meant net increase, the failure anywhere in the relevant documents to state that there would be a net aggregate increase, let alone that it would be at least 1.17 gigatons, and to consider the implications of that for compatibility with Paris or generally for climate impacts, all reveal a failure to evidence, assess, and determine rationally. And this too, Mrs. Justice Thornton rightly found to be unreasonable, and you find that in 329. And I'll just give you one reference, the statement of Maxwell Griffin for the respondents, supplementary bundle, tab 61, page 520, paragraph 128, where he says there will be a net global reduction in emissions. A qualitative assessment is meaningless. The words significant or very large could never have formed the basis for a rational decision maker to conclude on the impacts of the Paris Agreement. That is so, however the respondents put their case, which of course we say has been a moving feast. We accept that had the respondents taken the view that the emissions were so large and so significant that financing the project would evidently not be compatible with the UK's obligations under the Paris Agreement, the position would be different. It would have been rational to say there is no point in quantifying these precisely because they are manifestly not in line with a low emissions pathway. But it was not rational to conclude that irrespective of the tonnage of GHGs that will be produced by this project, it is compatible with a low emissions pathway and or the development benefits are such that its financing is compatible. That simply makes no sense, we say. Mrs. Justice Thornton referred to the Gloucester Resources case, which we cite in paragraph 45 of our skeleton, and I'd like to take you to it. It's in Authorities Bundle, tab 44. So that should be Authorities Bundle 4. And because of time, I'm afraid we're not going to have time to go through it. I just want to highlight some points.
Can you give me a page number?
2558.
Thank you.
If you start at paragraph 486, you'll see a title, both direct and indirect should be calculated. Indirect is scope 3. And then 487, although GRL submitted that scope 3 emissions should not be considered in determining GRL's application for consent for the Rocky Hill coal project, I found they are relevant to be considered. This case wasn't a license application for coal in Australia, but very small emissions compared with this one. And then if you turn to page 2564, you get a heading, all GHG emissions contribute to climate change. And you'll see the paragraphs I'd like you to highlight are 514 through to 516. But you'll see that the judge, second line, in aggregate, the scope 1, 2 and 3 emissions over the life of the project will be at least 37.8 megatons of CO2, so tiny relative to the one we're dealing with. A sizable individual source of GHG emissions. It matters not that this aggregate of the project's emissions may represent a small fraction of the global total. The global problem of climate change needs to be addressed by multiple actions to mitigate emissions by sources and remove GHGs by sinks. As Professor Steffen pointed out, global greenhouse emissions are made up of millions, probably hundreds of millions, of individual emissions around the globe. All emissions are important because cumulatively they constitute the global total of greenhouse gas emissions, which are destabilizing the global climate system at a rapid rate. And then I would like, my lords, if you would...
This is Judge Preston, I think, isn't it?
Yes, that's right. If you could possibly highlight the next page all the way through to page end of 2570. That's helpful, I hope, for your lordships to read at another point. I'm sorry I don't have time.
We have to read the whole case. It's over 100 pages.
No,
It's
just until...
Just dicta.
Just those few pages, because they set out important points from the Urgenda case, which, again, Mrs. Justice Thornton cites. So it's quite a good shortcut for your lordships to read those 5 pages through to the end of 2570. Now, in paragraph 64 of the respondent's skeleton, they say, the appellant cannot seriously contend that every time any decision maker considers whether or not something is good or bad for climate change, they are thereby legally obliged to produce a quantification of scope 1, 2 and 3 emissions. Now, our response to that is, well, it depends on what you mean by every single, but Gloucester was 35 megatons. And we certainly know that this project is vastly greater than that. So that was a relatively tiny amount. The quantity put down in the TCFD for disclosure is 25,000 tonnes. We've also referred in our skeleton to a case called Harland, which is a US federal case, and it's at Authorities Bundle 4, tab 50. It shows an extremely wide margin of appreciation given to the decision maker in the context of a licence decision. And the court still found that scope 3 absolutely had to be quantified. Because in the end, my lords, for the purposes of the Paris Agreement, scope 3 is the most important scope emission, certainly in a project like this, where it vastly dwarfs scope 1 and 2.
How does it help to quantify scope 3? I mean, how does it affect the decision? I mean, if it had been, you're telling us, if it had been 37 metric tons or whatever, it would still have been significant. If it's 808 megatons, it's even more significant. Doesn't seem to
So,
matter.
my lord, if you look at the statement of Greg Muttett, he gives you a 4-stage process of how you would analyse that. And I hope I will have time to give you the references to that.
Where's this Greg Muffet?
Greg Muttett is at SB Supplementary Bundle tab 64.
And which paragraphs is it?
Can you find it? It has 4 stages. So I'm going to turn to just 4 arguments made by So the court, we say, cannot do as the respondent requests, and Lord Justice Stuart-Smith did, which is namely look at the whole decision, wrap it all up, and ignore whether a material element was reached rationally. That submission was rightly rejected by Mrs. Justice Thornton. Any material consideration cannot be determined on an arbitrary basis. The same argument had been made in the Earthlife case, a licence case. It's in tab 43 of Authorities Bundle 4. And if I can take you to page 2436. You'll see the respondents submitted that the Chief Director considered and weighed the relevant factors and made a decision in good faith, and accordingly there's no basis for the court to interfere with those decisions. I do not agree. The issue we have to do with in this case is not whether the weighing of factors was reasonable. Earthlife case is that the Chief Director was unable to perform the weighing exercise because they did not have the relevant information to balance the climate change factors against the other relevant factors. As Mr. Budlender put it, it is simply impossible to strike an appropriate equilibrium where the details of one of the key factors to be balanced are not available to the decision maker. That is position here. My lord, the reference for Muttett is SB tab 64, page 574, paragraph 37.
Sorry, page?
Page 574,
Okay.
paragraph 37. So, turning to the respondents' arguments. First, it says climate change implications was only one of the many factors in the decision. That's at 61.1 of their skeleton. And we say simply that that doesn't mean the conclusions on it could be reached without the necessary evidence. And indeed, it wasn't just a material factor, it was plainly an important factor because of the disagreement within government and because of UKEF's position in regard to compliance with the OECD common approaches and international agreements. Secondly, they say there's no acknowledged method to consider consistency with the Paris Agreement or impacts on climate change, and that's at 61.2, and they make the same point at 61.4, where they say they were told by Wood Mackenzie that it couldn't be done, and by Caldecott and Clark that it could be done, but there was no established methodology. And again at 61.6, where they say that there was no clear-cut methodology for establishing impacts. Now we say in response that this again addresses the wrong point and conflates the question of avoided emissions with the prior and key point, indeed the most important question, and the first step in any analysis required, which is a measurement of the absolute quantity of Scope 3 emissions. And this is fully addressed in Mr. Muttett's statement, and I gave you that reference. It applies here, page 574. That's a summary, but my lords will want to read that statement. The respondents couldn't consider the question of impacts before they had considered the overall emissions that the project would create. And that is the case, however you look at it. UKEF got confused about this. It conflated the two. And it also didn't understand that carbon dioxide emissions are not significantly dependent on uses. They depend primarily on the carbon content of the LNG, which is a known fact. And this is explained by Mr. Muttett at page 577 of his statement, paragraph 46. The climate change report actually asked for an absolute quantification of Scope 3 emissions, and it did so for the very reasons that Mr. Muttett explains. It was not done, and it was basic, and the advisors should have done it. UKEF said that it wanted those numbers, but wrongly understood that Wood Mackenzie could not do them. But it didn't point out to Wood Mackenzie the greenhouse gas protocol, and that's at paragraph 301 of Mrs. Justice Thornton. Mr. Caldecott-Clark both said it was a big lacuna. Again, Thornton sets that out at 285 to 287.
Sorry, the previous reference to the judgment was
301.
301.
Thirdly, they say, well, UKEF was considering the question not as an environmental body, and you find that at paragraph 61.3, but as an export body. But with respect, as they explain, they have environmental experts, they have ECAC, you find this also in their annual report. It doesn't matter whether you're an environmental body or not, you still have to get the basic facts right. And they claimed to have reached a rational conclusion on climate change impacts in alignment with the Paris Agreement temperature goal. And it's accepted that it was a material factor. This is not, as Lord Justice Stuart-Smith said at paragraph 216 of his judgment, to quote, elevating the importance of climate change and the Paris Agreement to the decision to be taken by UKEF to giddy heights. It is simply saying that decisions should be rational and not arbitrary, a basic principle of the common law. Fourth, they say they weren't obliged to use the greenhouse gas protocol, that's at paragraph 62. But we do not say that the respondents are obliged to use the protocol. Our submission is that the greenhouse gas protocol is a method that was well established and available, and indeed that EAC, the Environmental Audit Committee, had told UKEF that it should use a year previously. Total, in fact, agrees with this, as cited by Mrs. Justice Thornton. It's up to UKEF what methodology it uses. Bayes used the Duke methodology overnight on the 29th of June. The point is that UKEF proceeded on the basis that a quantification could not be carried out, and it didn't carry one out. So, my lord, in conclusion, and I think I may have beaten the clock, Mrs. Justice Thornton deals with the evidence on Scope 3 in detail. And she concludes, having summarised it, that in the circumstances of this case, UKEF failed to make reasonable and legally adequate inquiries in relation to a key consideration in the decision-making, climate risks. The lack of information deprived ministers of a legally adequate understanding of the scale of the emissions impact of the project. And those, my lord, are my submissions.
Anything else?
No, thank you.
Thank you very much, Ms. Timor. Sir James.
I was ungrateful. I'm going to go back, if I may, and start with the applicable standard of review issue, which is technically ground 2. Then I'm going to deal with compatibility with the UK's obligations under the Paris Agreement and all matters to do with that. And then thirdly, I'm going to deal with Thameside. That's the conclusion that struck me as being a logical course to take. So far as the applicable standard of review is concerned, our submission, as you know, and the conclusion, unanimous conclusion of the court below, is that tenability is the standard if the court is considering the meaning and effect of an unincorporated international agreement which the executive has chosen to take into account. The standard is not correctness. For the conclusion of the court below on that issue, see judgment 121 to 124 and 262. And I wanted to address this issue and my learned friend Mr. Douglas's submissions by making 8 points, if I may. First of all, the correct starting point is dualism. In other words, the principle that unincorporated treaties give rise to no legal rights and no legal obligations in domestic law, including in no legal obligations public law. Therefore, there is no domestic legal obligation to comply with the provisions of such a treaty, and it is no part of the court's function to determine whether or not the United Kingdom has or has not acted, or would not be acting, in breach of an unincorporated international agreement of that kind. Can I invite you, first of all, to go to SC in the Supreme Court, which is in Bundle 3, tab 35, and the page I want is 1978. So tab 35, Bundle 3, 1978. My lords, I'm sure all of you will be very familiar with this case from the Supreme Court. Composed of 7 judges, as you see from the beginning of the case at 1942. The lead judgment is given by Lord Reed, and everyone else effectively agrees with that. And this was the case about there being a limit on social security benefits for people who had more than 2 children. It was the 2-child case that went to the Supreme Court. And at 74, or perhaps pick it up at the title above 73, you will see that the Supreme Court decided that it was appropriate to give guidance to all of us on 3 preliminary issues. And the first of them, as you see from the title above paragraph 74, was compliance with unincorporated international law. And I'm going to invite you in a moment to read yourselves a couple of, or 3 or 4 paragraphs from this section, which runs all the way through to the end of paragraph 96. I'll try and highlight for you the key paragraphs for present purposes. But in short, what the Supreme Court have done in this section is to reassert the, what might be described as the orthodox Lord Oliver from J.H. Rayner position. That draws a clear line under the constitutional principle of dualism between those things, those treaties which have been brought onto the domestic plane through legislation and those things which haven't, i.e. the unincorporated international treaty. And the particular issue that arose in this case, it's a point I'll come back to, was something of a hybrid, because the issue that they were considering here was the extent to which the courts should be ruling on the question whether the United Kingdom, in this context, in the context of the two-child rule, should rule whether or not the United Kingdom was in breach or not in breach of the United Nations Convention on the Rights of the Child. And that analysis was being said by the claimants in that case to be relevant for the purpose of the court considering the questions of justification arising on a discrimination claim principally, relying on Articles 8 and 14 of the ECHR. So I described it as a hybrid because to some extent the thing had been incorporated, as it were, because the HRA brought the ECHR in, and the ECHR has a set of principles that say you can rely upon international conventions and agreements for the purpose of interpreting. But even in that context, there is strictness. So the paragraphs I would invite the court to read, if I may, as I say, reasserting the orthodoxy. Can I invite you to read 75 through to the end of 78, if I may?
Tin Council.
Tin Council and JH, Rayner and all that, yes, exactly. But the reason that this orthodoxy was important was because, as I say, the lower courts and the Supreme Court, to some extent itself, had in previous years, as it were, drifted closer and closer to saying, well, if you can show there's a breach of the UNCRC, then you're pretty much home on a no justification argument if you're the claimant for discrimination purposes. So there was a correction. That's why in the latter part of this section, they address and, correct may be too strong a word, but gently sideswerve some of the previous authority on this issue.
Do they cite Launder?
They cite Launder.
What do they say about it?
No, they don't cite Launder in this case, no. No, they don't. I'm going to come to Launder. Just finishing on this case, if I may, paragraph 84. And it might be thought that the word even could be inserted into the second line somewhere. Because, as I say, the Human Rights Act has brought in the convention, and the convention sometimes relies upon international conventions for the purpose of interpreting its rights and obligations. So 84 is the next bit, and then perhaps one other bit. You don't need the intricacies of correction or not of the previous case law. Paragraph 91. A summary of what's gone before in the last 4 or 5 lines, picking it up on the letter by the letter G on page 1983. Then paragraph 91, as I had explained, you see from there to the end of the paragraph. Fundamental principle of our constitutional law. And it was no doubt that sort of thinking which led the Supreme Court in the Friends of the Earth case, which at least some of you will be very familiar with, in the Friends of the Earth case behind tab 26, page 1482, is the first page of that. And for present purposes, for the purpose of this first point, I wanted paragraph 108 on page 1510.
Sorry, I didn't get that.
1510. It's paragraph 108 in Friends of the Earth Supreme Court. This time a judgment produced by the Deputy President Lord Hodge and Lord Sales.
Which paragraph?
108, bottom of the page.
We're 2 pages. We're 2 pages out.
I'm so sorry.
It's not your.
It's a paragraph 108. It begins, although the point.
Yeah.
On a slightly different point, but the same theme. So the mere fact that the government has ratified the Paris Agreement did not constitute it as government, even as government policy.
Does that matter if it says it's going to apply it?
My lord, I'll come to that. I think it does, if I may respectfully say so.
It does.
But I rely on 108 at this stage simply for the proposition that this is another example of, as it were, that dualism in action. Even the fact that you've gone out of your way and ratified it under the convention, or even if Parliament has itself gone through the procedures in the Constitutional Reform and Governance Act, which it would have to do nowadays, that doesn't even make it government policy. And there is very, very good constitutional reason for the concern about treating unincorporated treaties as law. And it's at that point that we get to Philip Sales, as he then was, in the LQR. If you go to tab 52 in bundle 4.
Well, hang on. I mean, this Heathrow case is long after that. I mean, this is his judgment.
It is.
Yeah.
It is. But I'm going to this to show you the analysis that then feeds into Corner House, Lord Brown, and we come much closer to the heart of what we're worrying about, which is, my Lord rightly drew my attention to, what happens if the government says it's going to take it into account and doesn't. Okay. So, but I'm going to the Sales and Clement article because there is a clear and comprehensive analysis of the constitutional underpinnings for that distinction, for dualism, and the worries about what would happen if that became too porous. Mm-hmm. So 3066 should be the start of it. Tab 52 in bundle 4 if you're in the hard copy. And again, just to invite you to read selected bits, if I may, rather than reading them out aloud. 3066, the second paragraph beginning in a dualist state. Making the basic point about dualism. And then over the page 3067, the authors, including Philip Sales, set the constitutional context and explain why dualism exists. And you'll see in the first paragraph, last sentence, the primary principle, what they described in the previous sentence as fundamental constitutional principles, the primary principle is that of sovereignty of Parliament in the making of laws. So the central concern is it's Parliament that makes the laws. It isn't the government that makes the laws by signing up to treaties on the international plane. That's why transposition, bringing the unincorporated into domestic law, is so important. And that was the foundation of the Miller case, as you will recall. Then the third paragraph on that page, beginning the second principle. If I could invite you just to cast an eye down there.
It doesn't make it law, but it might make it policy.
It doesn't make it law, but it might make, well, it might, but well...
But the Supreme Court says it doesn't.
The Supreme Court says even the act of ratification doesn't. Query whether you go further and say, well, if you say you're going to... It's a bit,
well, it went further without revisiting the territory too deeply, because ministers had said what they did at the dispatch box about it, which was part of the factual matrix. But I don't think that touches your argument here, actually.
No.
But
I mean,
all I'm saying is it wasn't ratification simplicitary,
no.
It was rather more. But that doesn't touch the principle you've just taken.
Indeed, it might be thought to reinforce it if there was more. But anyway, in that second paragraph, you'll see the first sentence in particular, and the second one. Separation of powers, legislature, executive, and courts. The legislature makes new laws, the executive governs within the framework of those laws. Established that the Crown and the executive cannot change the law by the exercise of prerogative powers. And you'll see why I say that was at the heart of the Miller case, because the case on proclamations was the one that sunk us, as I remember. In Miller 1, about whether we needed an Act of Parliament following the referendum to Brexit. So picking it up on the paragraph below that, without dwelling on unhappy memories, care should be taken penultimate paragraph on the page. Can I invite you to read the next two paragraphs, please? From care should be taken over to about 6 lines on the next page, 3068. You'll see, in effect, in those paragraphs, what is being said is, here's the constitutional rule, it exists for jolly good reason, separation of powers, but that is given practical force by the idea that very often international treaties, which depend upon consensus and all the rest of it, and a muddle between states, might well be drafted, it might be thought they were talking about the Paris Agreement, might well be drafted in terms which are, as it were, unsuitable as an anvil for creating domestic law. That's why the parliamentary transposition process is so important, because it involves not merely a constitutional legislature putting its imprimatur on domestic law, but also operates, as it were, as a filter process to ensure that domestic laws, which might well contain, for example, penalties, are properly modulated so that they can be rules which would conform to the idea of law, using that concept in its ECHR sense of being both accessible and relatively predictable and intelligible. So that is an important aspect of it, the mediating process between the two. Then they turn on page 3069 to international treaties, and they cite in the passage, because they're dealing here not merely with treaties but with CIL, customary international law, and all the rest of it. But you'll see unincorporated treaties as the first of the italicised headings on 3069, and they cite J.H. Rayner, unsurprisingly, that the SC returned to, the Supreme Court returned to in the SC case, and then set out the clear principles that the House of Lords from way back at ex parte Brind and so on, they deal with that on the next page, 3070, under the title No Direct Effect. Just invite you to read the first sub-paragraph under that heading. And you'll see the reference in the second paragraph under that heading to Brind. Of course, Brind was the case that established pre-ECHR that you couldn't seek to introduce the ECHR through the back door when Parliament had chosen not to incorporate it at that stage. You all no doubt remember Brind. So that's that. They return on 3071 in the second full paragraph beginning, but this is not the rationale for the dualist theory, to what the true rationale is, namely that the Crown cannot change domestic law by the exercise of its powers under the prerogative, a rule reflecting the sovereignty of Parliament and its primacy as the domestic law-making institution in our Constitution. Then they go through various potential uses, legitimate uses, to which the unincorporated treaty might be subjected in domestic law, which didn't offend against that fundamental constitutional principle. And then they come at the bottom of 3072, perhaps importantly, they come to the title Unincorporated Treaties and the Exercise of Administrative Discretion. And Justin's going to invite you to read that and down to the end of the next page in a second. Before doing so, can I just invite you to note that the footnote at the bottom of page 307277 is to Brind.
I'm not on the right page. Which page?
3072.
You may have a slightly different version.
Maybe I'm
in
not
this
using it.
printout, unincorporated
Maybe you're on page,
treaties.
sorry, 3073 it starts.
Yes.
And Sorry, I was using an old one, so maybe that's got.
Okay, I've got it.
Internal page 7.
Internal page 8.
Internal page 8, it looks like it is on yours. There should be an italicised title on incorporated treaties and the exercise of administrative discretion. Footnote 77 is brimmed. Can I invite you to read that page down to the next italicised heading? And you will note, you can skip quite a lot of it, because from halfway down that page, roughly, halfway down the big long paragraph, is the bit from Lord Brown in Corner House.
Yeah.
So it might be thought, I say so with respect, that article up to that point and including that section is a compelling analysis of both of the constitutional context that you're having to grapple with and of the serious constitutional issues that provide the basis for and should shape the issues to which we're coming, and begins, as you see, the consideration of Launder and works out where it sits within that constitutional framework. And you can see echoes of this, I respectfully submit, you can see certainly echoes of this idea, this line of thinking in the judgments to which no doubt Lord Sales contributed.
Well, one might have thought that it was perfectly reasonable for government to say, we want to give effect to this treaty, but it's difficult because the language of treaties is difficult. We have to reach an executive decision as to whether or not we are giving effect to it, because we've said it's a factor to take into account. And all we can do is do our best to evaluate the advice we've got and make the right inquiries, Tameside and all that stuff, get the right information, and reach the best conclusion we can. It shouldn't, you would say, be up to the courts then to say, ha, got you. You
treat it like domestic law.
Treat it like domestic law. Will interpret it as a deed. Get a chancery lawyer to look at it and say the government's wrong, and unwind everything government has done in good faith. Now, I mean, that's not this case, mind, but if it were this case, you would say that's a perfectly reasonable approach. And as I said to Miss Seymour, the Lord Brown characteristically sort of hits the nail on the head, doesn't he, in Corner House, by saying, well, you know, that you've got to take a sensible view about the court's review of government action.
He does. I don't say this is the beginning and the end of it. This is simply the first proposition. What this does is to set the constitutional framework within which the issue we're going to have to grapple with sits.
Yes, it's a different issue here, but yeah, I see.
But not so different in the sense that we're having to grapple with the question of how far launder goes and what is it authority for and how all of that works. But the constitutional considerations which we've just been looking at, in my respectful submission, do shape and should shape the court's thinking and the court's analysis on this range of issues, not least because of the point to which Lord Sales keeps returning in that article, which is that there is a setup for the making of laws, and you can't have a situation in which the government buzzes off into the international plane and says, I'm going to sign up to an agreement that says it'd be a jolly good thing to put people into slavery.
But the analysis does acknowledge launder and weaves that into the overall
It does.
reasoning. No doubt you're coming to that in one
I
of
am
your
coming to
subjects.
that, but this is a start, and I'm going to come to launder because I'm obviously going to have to grapple with that because that's the heart of my learned friend submission. That's the first point, anyway. I'm afraid of the 8. I'm sorry, I know the numbers are long. But second point, we are not here dealing with a situation in which international law, an international treaty, has been incorporated, or in which there is legislative authority, to put the same point in a slightly different way, in which there's legislative authority for the court to interpret it. And there is limited or no assistance, therefore, to be derived in relation to our issue from those cases where that is the position. In other words, where it has been incorporated. And there are numerous examples of those. My Lord the Master of the Rolls will recall recently in relation to the Vienna Convention on Diplomatic Relations, which have been incorporated into domestic law word for word by scheduling certain of the articles in that convention to the Diplomatic Privileges Act of 1964. And in those circumstances, of course it is the position that the domestic courts have to interpret what those articles mean. And for that purpose, of course it is the case that one has regard to and uses as the mechanism and framework for interpretation the VCLT, the Vienna Convention on the Law of Treaties, as indeed we did in the AG case, as my Lord the Master of the Rolls will recall. And it's exactly the same point in relation to the Reyes and Malek case, which was also about that, as you recall, a different article to the one that we were considering or thinking about in AG, but nevertheless the same convention, same idea, an incorporated convention. Adan, to which my learned friend made repeated reference, is another example. Can I just invite you to take that up very quickly? It's in Bundle 3, tab 36. Page 2054 is the one that I want, because that's the start of the analysis of concern here. Sorry, 2056, I'm so sorry. 2056, tab 36 in Bundle 3. And just to remind you, my learned friend, Mr. Douglas, went to this case because at 2057 you will see citation of the well-known bits of Article 31 of the VCLT. And he said, aha, look at that, there they are, they're in a domestic context, it's an unincorporated treaty, he said, the Refugee Convention, and they're still looking at the VCLT. And we respectfully submit that that is fundamentally to misunderstand this case. If you go back to page 2056, you will see why the court was in that territory. Just have a look at the first 4 lines on page 2056. So the relevant domestic legislation, if you want it in the raw, it's on 2054 by the letter C. you will see that one of the specific, as they say there, one of the specific preconditions to being able to grant a certificate authorising the removal was that the person to which the asylum seeker was going to be sent wouldn't then remove them to another country or territory otherwise than in accordance with the convention. And the convention there is the Refugee Convention. So the Refugee Convention itself is an unincorporated treaty in the sense that we haven't done what we did with the Diplomatic Relations Treaty. It hasn't been brought in that sense, but it has been incorporated because you have the point, I don't labour it. So that's Adan. I've already given you the SC example of a context in which the domestic courts are in a similar situation, something of a hybrid it might be thought, under the HRA. So the HRA, you know the technique, the HRA appends and schedules the rights in the ECHR that it's incorporating, not all of them, but most of them. And it does through the legislative prism that are the controlling constitutional conditions within the remainder of the Act. But the ECHR is scheduled. And that was the situation in which the Supreme Court were considering the issues about unincorporated conventions in SC, because they were considering whether or not you should be deciding or not deciding breach of some separate international convention for the purpose of informing your approach under the ECHR. But the basic constitutional permission to look at the ECHR and interpret it and do all of that was in the HRA. That's direct transposition. And Benkabush, which my learned friend took you to, Lord Sumption in the Supreme Court, Benkabush is in exactly the same situation. It involved consideration in particular of Article 6 rights, that's Article 6 ECHR rights, in the post-HRA world. So the ECHR has then been incorporated, and you are then considering customary international law and all the other things that might affect the idea or ingredients of the fair trial right in Article 6. It also, for good measure, involved interpreting EU law, again, directly transposed under the 1972 Communities Act. So Benkabush tells you nothing. Worth going there very quickly. Again, sorry to jump around in the bundles. This one is in bundle 2, tab 21, page 1099. And the paragraph which my learned friend took you to and which is sidelined helpfully is paragraph 35 on 1131.
But it's talking about incorporated obligations.
Exactly so. And acknowledging that there may well be circumstances in any event where tenability is the right standard. But Lord Sumption has a constant theme on this in a number of, or a range of cases from Gentle onwards, where he was, I think, the advocate for the government, the QC for the government. But the constant theme is, if the issue is justiciable, you better decide it. But what he's talking about is, if you've got that requirement through the proper constitutional prism of the legislation bringing the international law into effect or requiring the court to look at it as in Adan, then you decide it, and you have to decide it.
So Benkabush doesn't bear at all on unincorporated treaties, at all?
Not in that sense. And what we're dealing with here is the punchline of the second point, is none of the above, but how, absent that legislative authority, the court should react if Her Majesty's government takes into account an unincorporated international treaty.
I mean, this is the nub of this
as a
case.
matter of pure public law.
I mean, you've only
That's the
got to
question.
point 2 so far, so I'm assuming you will get within points 3 to 8 to deal with that $64,000 question.
That's exactly what I'm coming to now. I hope you will forgive me for laying the constitutional groundwork as it affects things.
Forgive that.
Third point, there is no public law obligation to take into account unincorporated international law or treaties as part of decision making. Put it another way, unincorporated international law is not a mandatory relevant consideration. You'll recall the cases cited to that effect in the Sales and Clement article. It is implicit in any event in paragraph 108 of Friends of the Earth, which we went to, where ratification and perhaps more, even ratification and perhaps more wouldn't do it. It's also evident, it might be thought, from the legislative provisions, of which there are a number, which do require international law to be taken into account in limited circumstances. We've seen an example of that, the precondition in Adan, but there are other examples of that, including in a case where a judgment, I think, has recently been handed down in relation to the Western Sahara and the taxation issues arising out of Western Sahara and the disputed sovereignty over Western Sahara. Mrs. Justice Cockrell handed down a judgment the other day, whose name escapes me, even though I was in it. But that was all about a provision in the 2018 Taxation Cross-Border Trade Act, Section 28, which positively required, in certain circumstances, the Secretary of State to take account of international law of particular kinds. So you've got legislative provisions that provide for that. So it all grist to the mill that says it is not a mandatory relevant consideration. So it is clear that if the executive is exercising a power and does not take international law, which is not incorporated into account at all, there is nothing unlawful about that.
I mean, to put it the other way, if government decides to ignore its treaty obligations, that is not justiciable.
It doesn't sound in domestic law.
In domestic law.
And that's the concern. That was established in Brind, and that's the concern that leads to the disincentivization effect. And I'm going to come to Corner House in a second, but just note here, note final sentence of para 44 in Lord Bingham's speech in Corner House.
Perverse incentive.
Exactly.
Sorry, I'm behind.
No, it doesn't matter. We're going to come to it in due course. I'm simply inviting you to note at this stage, para 44, final sentence, Lord Bingham in Corner House, bundle 2, tab 16, page 786, which I'm going to come to specifically when I take Corner House as a whole.
Thank you.
But that's what my Lord Justice being described as the perverse incentive point. Wouldn't it be a shame? Fourth point. It is, of course, possible for the government to have regard to an unincorporated convention as part of its decision-making. But if you do so, and when considering the public law consequences of that, it is important to recognise that the correct starting point is that this is not domestic law. It is not a mandatory relevant consideration, and ratification does not make it enforceable policy. What is it then, if the government does take it into account? It falls within the range of considerations for the rational judgment of the Secretary of State or other public authority. It's for the Secretary of State to decide, subject to rationality, what to take into account and how to weigh matters. That is the conventional public law approach.
Well, that's Creed NZ.
Creed NZ, exactly, and DSD and the Parole Board, the War Boys case, and all of that. But all of these principles, Thameside, mandatory relevant consideration, they've all collapsed in the end into rationality control through those sorts of cases. Justice Cook and Creed NZ and all that. That's the fourth point. You treat it like any other thing the Secretary of State takes into account. Fifthly, and this perhaps comes closer to the nub of it, there is good reason in principle, we submit, for that approach in the context of unincorporated international law and against the position under which a mere decision to take it into account, or the mere fact that you've reached some view about it, in some way transmutes international law, brackets unincorporated, into a domestic legal standard for the court to interpret as if it was domestic law. A couple of sub-points under that, if I may, under this fifth point. The starting point we submit is not the principle that error of law is correctable. Error of domestic law is correctable. If you apply that principle to an unincorporated international treaty, it begs the very analysis or the very question that the analysis is aiming to answer, which is whether the treaty is or should be treated as law in the sense of creating domestic legal standards to be interpreted by and enforced according to public law principles by the court.
Well, I mean, that's just the other facet of what I put to you a minute ago, which is if government decides not to adhere to its treaty obligations, it's not justiciable under domestic law. Yeah. So in other words, if you get it wrong, it still doesn't matter. Yeah. But this is a different case, because this is a case where, on one analysis, government has said it is going to comply with a particular obligation under that treaty.
Well,
on one
it's taken it into account and formed a view about it.
Well, I mean, you'll come to it, but on one analysis, it is said against you, government said publicly it intended to interpret the treaty in a particular way and give it effect, and then it didn't.
My submission is that, even if correct as a matter of fact, that wouldn't do it. That's
but that would turn on a different question, which is the question of whether that action by government turned it into government policy, which made it enforceable in domestic law.
Well, that isn't how the argument is put.
Well, I know you're going to say that.
It isn't how the argument...
I think it is, Sir James, for this reason. Well, I think it at least could be. I've looked very, very carefully at ground 3 in the grounds of appeal. And ground 3 in the grounds of appeal doesn't say anything about unlawful. It says irrational. And it says it's irrational to do what it did because... I mean, I say I've looked carefully, I can't even recite it now, but we'll come back to it. And on one analysis, what I've put to you does come within ground, or could come within ground 3.
But if it's going to be analysed as irrational not to comply with policy, then you have to A, build a distinction which is based on whether the government asserts something or receives some sort of advice about a view about compliance with the international treaty.
This is not what you've come here to argue.
Yeah, and in some way that's different from take account of. You'd also have to grapple with the concern, which is, again, as you will well recall from another of the cases you were thinking about recently, you then have to grapple not merely with the question that was grappled with in Heathrow in a statutory context, or Friends of the Earth in a statutory context, is it policy for the relevant sense of the 2008 Climate Change Act? But you'd also have to grapple with the ordinary concomitant of a policy challenge, which is that policy as a matter of public law carries within its bones the idea that you can depart from it for good reason. So you get into all sorts of difficulty if that's the argument that is sought to be run. If it's put as irrationality, as you put to my learned friend on frequent occasions, is it irrationality? Yes, it's the famous first sentence of Wednesbury. It's error of law. I respectfully submit that that's a category error.
But, my lord, we are saying that the respondents purported to apply their policy. And
Sorry,
they purported to apply their policy and came to the conclusion that this was consistent with the United Kingdom's obligations under the Paris Agreement. So it is not that they did not apply their policy. They did apply their policy, came to the conclusion this was Paris Agreement compatible, and on that basis took their decision. At least that was a material consideration in their decision.
I wonder whether this really does come back to Launder.
I think it does, and I'm going to come to Launder because I'm going to come to the case law specifically.
Yeah, because that does seem to be where these points converge.
Yes, and the argument against me, which is the one I'm grappling with at the moment, the argument against me is, well, there's Launder, it's binding. That's the end of it.
Yeah.
And that's the argument. But then,
anyway, you're coming to that.
I'm coming to that. But the good reason in principle for not going down that route is the one I'm on, which was pretty much the constitutional groundwork, and lots of the spade work and the themes were set out, or at least floated initially in that Sales article we looked at, the Sales and Clement article we looked at. But my first sub-point under this in principle argument is that simply saying, well, error of law is correctable, this is an error of law, is a category error. We know now, and it's very clear, that they are constitutionally different.
Sorry, you're going to have to explain, just pad that out a bit for me, because I don't think I'm with you.
Yeah.
So, category error meaning what?
Category error meaning that error of law is correctable refers to domestic law.
Oh, yes.
And what is being done is to transpose that and to take hold of it and say, so we can say, if we can find any old unincorporated treaty, if you breach it, that's an error of law. Subject, no doubt, took it into account and made a statement about it or whatever it may be. But that is not how it works, because unincorporated international treaties, which we're dealing with here, which have not had any legislative transposition, the only thing that brings them close to domestic law is the executive's say-so or reliance upon them, perhaps unsurprisingly. And the reason it's a category error is because those two things, domestic law and unincorporated law, CSC, are constitutionally different. They're different in terms of the court's role, and they're different in terms of the executive's role.
But even if it's not an error of law, for the reasons you've given, it could be irrational.
Certainly, irrationality is a completely different head of challenge.
Well, irrationality is what's in the ground.
Yes, but I've got to take the argument in stages. The argument I'm addressing here is the argument that says...
This is the quiet court.
Yeah, tenable stand... I'm very happy for it not to be a quiet court, but what I'm addressing here is the argument that says, no, don't worry about tenability. That's nonsense. You can't possibly have tenability. You just treat it like domestic law. There's a correct answer and there's an incorrect answer. And my submission is that that isn't the right approach. And at the moment, on my fifth point, I'm on why that isn't the right approach.
No, but what I mean, just to finish this, I mean, you know what's swirling around in my head because I've said it a dozen times, but it might be irrational to say there is a correct answer to what this treaty means, and we intend to give effect to that correct answer, and then not do so.
Yeah.
That wouldn't be an error of law, necessarily. It wouldn't matter whether it was right or wrong. You could have got it diametrically wrong. If you'd said, we intend to give effect to this treaty by only ever using wood chip boilers in England, and that is what we think the treaty means, and then if you did something else...
Then that would be irrational.
That would be irrational.
Then you get to irrationality. You do, but to some extent, framing the argument that way, I'm afraid lands Mr. Douglas's argument in terrible trouble, because then you are looking at the correct meaning. There's obviously a distinction of sorts, at least, between interpretation on the one hand and application on the other. And on interpretation, if the whole standard is rationality, then that's tenable view. What tenable view does is brings rationality to the interpretive party.
Yeah.
And I respectfully submit that that's exactly the right approach. That was exactly what was underpinning the Sales article and all the rest of it. And there are good constitutional reasons for that. And that is not least because the executive will very often take international law, unincorporated international law, into account, precisely because it doesn't want to do what my Lord has described, which is to say, well, I don't care. They do care, and they do take it into account, and they shouldn't be disincentivised from doing it, was the Lord Bingham concern. And there would be, this was Lord Brown's concern, there would be a new swathe of law created, law in the domestic law sense, if the mere taking of it into account, or looking at it and then forming a view as to whether or not it was good, bad or indifferent in terms of your compliance or your meaning or your interpretation of it, if that created in effect a domestic legal standard, to be approached by the court doing its own interpretation, saying there's one interpretation, if you depart from that, that's the end of it, then there are real difficulties. It would create a situation that was both very concerning constitutionally and very concerning in terms of the practical operation of government, because, as I say, government is very concerned. Indeed, as we know from the Gulf Centre case, it's part of the ministerial code, apart from anything else, that ministers are expected to comply not merely with domestic law but international law. And international law is therefore, unincorporated international law, is therefore a special thing, if I can put it that way, in terms of taking it into account. There's perhaps a flavour of a separate point about this, but by taking it into account, what the executive very often is not doing is to commit itself, internally or externally, to any particular meaning or any particular interpretation of it. And to some extent this chimes with some of the exchanges you were having yesterday. There may well be a number of different possible meanings, and the more, go back to the sales article, the more aspirational the language, the more loose it is, the more it represents compromise, the more different possible meanings there may be. The expressions in the international treaty may be more or less hard-edged or aspirational, and they may be the product of negotiations. There may be deliberate fudging, as it were, in order to get everyone to sign up to it, particularly if you've got large numbers of states involved. And very often as well, the meaning of an international treaty, an unincorporated international treaty, will itself bear on what is normally regarded as forbidden territory for the courts, using that concept from the Abbasi judgment about Guantanamo. In other words, foreign relations and foreign policy. That, in essence, was why the court declined to do any interpreting of the relevant UNSCR, UN Security Council resolution, in the context of the Iraq War in the CND case. But it's simply illustrative of the fact that the government may either have a position on meaning or want to keep its position on meaning open, as it were, in case its future policy position or present policy position should lead it to take a particular position A or another position B in policy terms. So you will very often, and for good policy reason, not be conducting some form of absolute exercise, but even in relation to interpretation, you will be conducting an exercise which looks at ranges, a risk-based approach, as my lord put it yesterday. You're not dealing at all in the same way with the position as it would be if it was a domestic legal standard. And if there's a statute that says X, Y, Z must happen, and there's an issue of interpretation about what X, Y, Z are, then it's no good the government saying, well, I think it's X, but it might be Y. The fact of the matter is that the court would have to rule, the court would have to interpret it. It would be the final arbiter, there would be a single interpretive answer. That is not the position in relation to unincorporated treaties for all of the reasons that I've explained. It simply does not fall into the same bracket. And the court's function is very different when dealing with those sorts of international unincorporated obligations. And they don't just go, those points don't just go to the ease or difficulty of the court entering the meaning arena and simply treating it like a domestic legal standard for them definitively to opine on. They go to the constitutional propriety of the court doing so.
I mean, we're still on 5, I know, and we're going to get to launder. But launder is important, but may not be absolutely critical, because it seems to me that the case against you, really, if it's not you set up a policy for yourself and didn't follow it, that's irrational, because that's not really what is said. then it is you decided on day one that you were complying with the treaty by entering into this agreement. And on day two, you said it was unlawful under the treaty to enter into this agreement. Now that is the high spot
It
in
is.
the case. On
My
the
answer-
30th of June,
Yep.
the government decides absolutely clearly that this is compatible with the Paris Agreement, and on the next day, it publishes a document that says it is not compatible with the Paris Agreement.
Neither proposition is right, is going to be my answer to that.
Well, okay.
But I've got to come to that.
If it were right, you can see how that might look like something irrational.
I can, and I'm going to have to deal with that. But
Yeah.
my answer, I hope it will take as a flag at this stage, because that obviously sits in quite a separate chunk of the argument. I promise I'm coming to it, and I
Yes.
promise I won't take too long on this.
No,
but
no.
it
No,
is
I mean, I
it
think
is important that
this
this
is
issue
all-
of principle. I'm coming to the
Logically, it
case.
wouldn't make the decision taken on day one either wrong or irrational. That's not the logic of that scenario at all.
It isn't.
Nor would it make the decision taken on day two wrong or irrational, for that matter.
It would illustrate a range of views as possible.
Our focus must be, but within the context of the facts around it, on the decision which is impugned by this challenge. And that was a decision to fund this project. Taking into account, as the government did, the Paris Agreement.
Yes.
And the question is whether that is infected by illegality
It is.
or irrationality. That is the question in the case.
I respectfully agree. And the reason I'm taking a little bit of time on this is because if you get to the stage where that is the correct analysis, inherent within that analysis is the idea of rationality being the standard, or tenability, or whatever you want to call it. And that brings with it the idea that there are ranges of views. And this is a nuanced exercise. And I do not accept, I put down the marker, I repeat it, I do not accept either of those base propositions. But I'll come to that if I may. I'm sorry. I know how my Lord is keen to get there, but that at least shows you where I'm going to go when I get there. So that might do for the moment, if you'll forgive me. I was going to take you back to Friends of the Earth, if I may, just for one other paragraph. Bundle 3, tab 26, page 1515. This is the last of the points under 5, you'll be glad to hear, so then we'll be moving on at a rate of enormous knots.
4 was very short,
4 was very short.
commendably short.
125.
1515, you said.
125 on 1515, paragraph 125. And you'll see the analysis there, starting just below the letter F. On the contrary, the Secretary of State took the Paris Agreement into account to the extent the obligations under it were already covered by the measures under the CCA 2008. He gave weight to it and ensured that those obligations would be brought into account in decisions to be taken under the framework established by the AMPS on proper analysis. The question is whether the Secretary of State acted irrationally in omitting to take the Paris Agreement further into account or give it greater weight than in fact he did. So that's bringing, as it were, the rationality standard back in to those issues, and it's a short hop, I respectfully submit, to the next point. So the case law, if I may.
Is it 6?
This is 6. Strong support in the case law is 6. And my submission here is that there is no general principle, can I invite you to underline general? There is no general principle of the kind that my learned friend asserted from Launder, tab 10, or from Kebeline, tab 11 in the bundle. The true position is that those cases sit and are perhaps the start of what has been careful and ongoing consideration of the range of issues, how and when the courts should react to the government taking into account unincorporated treaties. those cases did not even purport, to lay down a general principle of public law across all contexts. And indeed, it would be extremely surprising if they had done, because it would have crashed through the constitutional divide that is dualism. It would have given rise to all of the problems identified by Lord Brown from the Lord Sales article and in his own right in that passage in Corner House. And the House, in neither case, certainly as I recall in the first of them, engaged in any sort of exploration or analysis of the constitutional issues that we see in the Sales article. And of course there is no grappling in those cases with the reassertion of the modern orthodoxy of dualism in SC in the Supreme Court and Friends of the Earth in the Supreme Court recently. So the later cases do indeed consider the application of those constitutional issues, and they refine the approach. Corner House in particular. I said I'd come to it, so I do. Bundle 2. No, bundle 3 perhaps. Tab 26.
Page 173.
No, that was Friends of the Earth, sorry.
Page 173.
Yeah, forgive me.
If the applicant is to have an effective remedy against the decision which is flawed, because the decision maker has misdirected himself on the convention which he himself says he took into account, it must surely be right to examine the substance of the argument.
Yeah, so that's in the context, is a submission. That's in the context of a human rights challenge, and the reference to
Not incorporated in there.
unincorporated, yes, but and the reference to effective remedy is to Article 13. And I respectfully submit that the question is, does that establish a general principle across all situations in which the government takes into account an unincorporated international treaty? And the answer to that is plainly no.
There's an irony, isn't there, about the direction of travel of our highest court in prior to incorporation in the Human Rights Act in 1997, and the direction of travel of our Supreme Court now.
Yes, that's certainly a possible theory.
Well, because I mean, this is pushing
something
the
about
boundaries. This case obviously pushes the boundaries.
Yes, and there have been repeated attempts, as you will recall, you may not recall, but there were repeated attempts to bring in the ECHR through all the various doors that Lord Sales was analysing in that article. Do it as an aid to interpretation, do it when you're exercising judicial discretion. There have been repeated attempts to bring it in. And that, as it were, represents, as it were, both Kebeline and indeed Launder represent the final hurrah of that, as it were.
You don't say this has been superseded.
I don't say it necessarily has been superseded, as long as you recognise that it was not intending at the time to be a general statement, that whenever the government said, take into account an unincorporated treaty, that created a domestic legal standard which you, the courts, could simply interpret. It's restricted to the human rights context, I respectfully submit. And when they came to consider the constitutional issues, they adopted a different approach to the general question. Now, I don't need here, perhaps all bets are off if we get up to the Supreme Court, but I don't need here to argue whether Launder was right, wrong, or indifferent.
I'm sorry to be old-fashioned about this, but where is the, if I was allowed to use Latin, I would say ratio of Launder, actually? I mean, sorry, I don't want, that's not in any way, I hope, an unfair question. It's just really to know what we're dealing with first. Because that I do think we need to understand.
May I have a think about that?
Yes, please, yes.
I'm not sure it matters for my argument,
No, maybe it doesn't.
more, but I'm not sure it matters for my argument, which is essentially you can take Launder as correct, and you can take the ratio of Launder, at least in relevant part, as being that they were prepared to interpret and consider Article 6, which was then an unincorporated treaty provision. Because even if that is so, my argument is, my submission to you is, even if that is so, and we don't need to debate whether that's right or wrong, even in the context of human rights, that even if that is so, it's evident that the courts since then have confronted and have addressed the broader constitutional issues which any such general principle would give rise to. And the answer that they've given is the one that we see floated in Corner House and that we see then taken on by Mr. Justice Lloyd Jones, as he then was, and in those subsequent cases. And they provide a nuancing for that. So whatever the position may be in relation to human rights or ECHR, we are here dealing with a development in the case law. That isn't a state of affairs unknown to the common law. And you see the beginnings of it in in Corner House, which I was going to go to. Tab 16. You know the background.
Sorry, a page would help.
Page, I'm so sorry, my Lord. I'm going to pick it up at page 786 in the speech of Lord Bingham. And you will see from paragraph 44 that Launder and Kebeline were the argument. That was the argument. Miss Rose stood up and said, well, there we are, it's the OECD, it's unincorporated. But the director said he'd taken it into account, didn't think there was a problem with Article 5 and carried on. So Launder was the argument. And it didn't at all strike Lord Bingham that the answer was, well, it's all been settled by Launder. No. Look at paragraph 44. Can I invite you to read that in its entirety, because that's the high point in relation to Lord Bingham. And the final sentence is the disincentivising effect that my Lord Justice Bean was referring to earlier on. But you see that the Launder argument, simpliciter, it's a general proposition, that's what they did there, do it here. It didn't strike Lord Bingham as being remotely self-evident that that was the right answer as a general proposition, for all of the reasons he gave, including in particular, towards the end of that paragraph, whether in the event there had been a live dispute on the meaning of the unincorporated provision on which there was no judicial authority, per contra Launder, where there was a whole body of authority on what Article 6 meant, the courts would or should have undertaken the task of interpretation from scratch, must at least be questionable, he said, would moreover be unfortunate if decision makers were deterred from seeking, and so on.
Well, if you take that paragraph 44 alongside SC now,
right,
you see that it would be eccentric to treat Launder as covering every aspect of every unincorporated treaty.
Exactly so. Exactly so.
We have to accept development in the law, and you and I have had this exchange before,
yes,
Sir James. But the fact is that the law does develop, and it has developed, and we can pretend it's all of a piece for the last 30 years, but some of us who know a bit more about it know that it's not exactly.
Right, and it does develop.
But that paragraph is quite significant, actually, more significant than the passages. I mean, as I've said before, I think Lord Brown put his finger on it, but that's very important in understanding the progression.
Exactly so. And if I may respectfully say so, my Lord asked yesterday who agreed with whom.
Yes.
And I think the answer to that is that Lord Roger agreed with Lord Brown.
And the rest agreed with Bingham.
And the rest agreed with Bingham. I'm not sure whether the Baroness didn't plough her own furrow, but it may not matter for present purposes. Lord Hoffman certainly did agree with Lord Bingham.
Yes.
And I think Lord Brown and Lord Roger might have done too. So it's Lord Bingham dubitante, as it were, which is the key bit there. And then you get on to the slightly fuller reasoning of Lord Brown.
In fact, Baroness Hale doesn't say one way or the other.
No, she doesn't. She doesn't touch it.
No judgment again.
But everybody agreed with Lord Bingham except Baroness Hale. So he is the majority there.
Yes, I mean, again, one may not want to be too old-fashioned about it, but whether it's obiter or ratio doesn't terribly matter. It's part of the direction of travel, and as some wise person once said, there's obiter and there's obiter, and if it comes from Lord Bingham and Lord Brown, it might be as well to pay attention to it. So Lord Brown I was going to go to next, if I may, and he's addressing the same thing from paragraph 62 onwards. You'll see this is Launder and Kebeline in 62. and then he refers to CND. That was the CND case I referred to earlier on, where they declined to interpret the Security Council resolution in the context of a challenge to the declaration of war in the context of Iraq, or the war in Iraq, anyway. And generally is on the same theme. And then you'll see he gets into 65, which you were taken to yesterday, and he starts off by saying, as I've acknowledged, there are occasions when the court will decide questions as to the state's obligations under unincorporated international law. This is for obvious reasons generally undesirable. And I respectfully submit that that is not wrong, as my learned friend would have you believe. That is obviously right. Because if it's unincorporated international law, it is not domestic law. And there are serious issues and difficulties with that idea of seeking to interpret something which isn't part of domestic law for obvious reasons. It's no good saying, well, the courts often do it, because the examples which my learned friend gives and that exist in the books, as it were, apart from Launder and Kebeline, are all examples, Adam being a paradigm one, in which there has been domestic incorporation, which doesn't raise the constitutional issues at all. Well, of course you interpret that, because Parliament has told you you have to. So we respectfully submit that's right, and then the remainder of this judgment, which really ought to be read in full from 65 through to the end of 68, is analysing the sort of factors that apply and should be taken to apply, which would give the court more reason or less reason to pause before embarking on any such exercise. Particularly, this is so, he says, second sentence of 65, whereas here the contracting parties to the convention have chosen not to provide for the resolution of disputed questions of construction by an international court, but rather, by Article 12, to create a working group through whose continuing processes it's hoped a consensus will emerge. Again, echoes of Paris. Really, this is no more than to echo para 44 of Lord Bingham, where a national court to assume the role would be a remarkable thing, not to be countenanced save for compelling reasons. And he then gets in 66 to saying why those compelling reasons might have been thought to exist in Launder and in Kebeline. I put human rights into the mix, but you'll see Lord Brown says at least a key feature in relation to those two were the points he puts into the mix in 66. And that isn't simply that the decision maker has said the decision would have been the same. Look at the beginning part of it. In the first place, as Lord Bingham points out, 3 lines into 66, there's a marked distinction between seeking to apply established convention, that's ECHR jurisprudence, to the particular case before the court as there, and determining the absence of any jurisprudence, whether on the point, whatever on the point, a deep and difficult question. There's echoes of that in Lord Justice Stuart-Smith's judgment. A deep and difficult question of construction of profound importance for the whole working of the convention is here. And so on. And then you saw the remainder of 66. 67, a critical question is not, and so on. Can I just invite you to read that? You'll see what he says in typically forthright terms in the second half of 67. It cannot be the law that, provided only a public officer asserts that his decision accords with the state's international obligations, the courts will entertain a challenge to the decision based on his arguable misunderstanding of that obligation, and then itself decide the point of international law at issue. And so the structure of this judgment is to say, that's the conclusion of principle I would have come to, and I've now seen the Sales and Clement article, which thoroughly confirms and provides the constitutional grounding for all of the doubts and worries that both Lord Brown and Lord Bingham had in relation to that approach. And you see what he says. I'm not going to go back over the article extract, which I identified when you looked at the article in the rule, but just go to the bottom of the little passage underneath the quote. The article goes on to suggest that the Launder approach must indeed be subject to limitations dependent perhaps upon the intensity of judicial scrutiny judged appropriate in domestic law terms in the particular context. No doubt this is so. Question will require further consideration. Equally no doubt, however, in this particular context, a tenable view approach is the furthest the court should go in examining the point of international law in question, and so on, reached a tenable view. So we do respectfully submit that that is important. And if you go to the next case, which is Mr. Justice Lloyd Jones.
Is that ICO?
That's ICO, sorry, it's page, yeah. The relevant bit starts at page 820, and it's paragraph 88 to 96.
By this time, Lord Panic had been brought in to make a point.
Yeah.
820.
Yeah, 820. Much of it will be very familiar because you'll see he cites over 820 and 821 from Corner House. You'll see what he says at the bottom of 92. Let's pick it up on 3 lines up from the bottom of 92 on page 821. However, launder and kebbling were treated in Corner House as exceptions to the general rule, Lord Brown at para 65, and justified as cases in which there was no live dispute over the provisions of international law in issue, or where there was a body of convention jurisprudence on which the national court would draw in deciding the issue before it. And then Lord Panic submitted that the present case could be distinguished from Corner House.
Yes.
I think Lord Panic might have been for the bad guy.
Yeah, well, Lord Panic was for the claimant.
Yeah. 94.
I don't know whether the claimant is in
I'm
your
sure he
language
wasn't. I was
the bad guys.
Oh, well, I withdraw it entirely. I was trying to work out which side of the argument he was on. 94 is perhaps the key bit.
Yeah.
I just invite you to cast an eye down that.
Yeah.
And for the remainder, so that's Mr. Justice Lloyd Jones, and I don't need to take you back, I think, to Elliot Smith behind tab 28 in bundle 3, or indeed Save Stonehenge, Mr. Justice Holgate at tab 29, because they are dealt with in the judgment in relevant part with relevant extracts quoted, judgment below of Lord Justice Stuart-Smith 113 to 115. But my submission in terms of this continuum of analysis is that this reasoning, the approach of Lord Bingham and Lord Brown, and of, as he now is, Lord Lloyd Jones, and then supported, as it were, in those later cases by Mr. Justice Dove and Mr. Justice Holgate, is all of a piece and strongly supported, we submit, by both the analysis of the Supreme Court in SC and the analysis of the Supreme Court, particularly 108 and 125 in Friends of the Earth, that we've looked at.
Sorry, 108 and?
It was 108 and 125, I think, with the
125,
paragraphs we looked at before.
Yeah.
I wasn't proposing to go back to that.
No.
So, seventhly, there may be features of the particular international law agreement, as we've seen from the case law, that make it more or less appropriate, including potentially not appropriate at all, for the court to engage in any ruling on the interpretation of a treaty. There's a fundamental constitutional problem with doing that, but leave that on one side. This is not a point which is simply to do with justiciability. There are no doubt some cases like CND, the Campaign Against Nuclear Disarmament, that was referred to in Lord Brown's speech, as you will recall, where the court won't engage at all with the issue. And you can call that justiciability, if you will, court declining to decide the point. And there are some cases where there is a complete legal imperative to do so, because the relevant international provision has been incorporated. The AG case and Reyes and Malky and Adan, that line of cases, that's the justiciable issue created by the legislative transposition of the international treaty. But what the later authorities do is to analyse the middle ground, as it were, and they consider and adopt a variety of factors or indicators that bear on how the court might approach it if it is looking at the treaty for whatever purpose. And we respectfully submit that those are important. You saw them from the analysis of Lords Bingham and Brown in Corner House. You saw them from Lord Lloyd-Jones in ICO. And you see them again, if necessary, in the judgment. I think it was a two-person, it looked like a divisional court, but I think it was the Court of Appeal in the Heathrow Airport case. Lord Justice Green and Mrs. Justice Whipple, as she then was, the Heathrow Airport case behind tab 27 in bundle 2. But just to give you, and again, I don't perhaps need more than is already in the judgment below from Heathrow, from that Heathrow case, judgment below paragraph 111 to 112, where there's quite extensive citation from that. But as I say, if you want it in the raw, it's a very long judgment, analysing all sorts of bits and pieces, tab 27 in bundle 2. Just to identify the factors, if I may briefly, the framing of the measure has always been regarded as important, the framing of the provision in question that you're being invited to interpret, the vaguer and the more broad brush and the more aspirational the measure, the greater the domestic court constraint in seeking to embark on an exercise of interpretation of it. And that heavily chimes with Lord Salis's analysis in the article of the difference between, the distinction between how domestic parliaments go about creating domestic law rules and international treaties are formed, as it were. But the more vague it is, the more aspirational, the less likely it is that the court will go there. And the or adopt any sort of intensive tenability analysis. The enforcement against informal political consensus point, you remember, from Lord Brown and Lord Bingham. And critically and very importantly, the lack of clear guidance on the case law under the international convention in question as to how the measure should be construed. That seems to have been regarded as an absolutely critical feature, which justified the court going there in Launder and in Kebeline, because the jurisprudence of the European Court of Human Rights under Article 6 was very well developed, and the lines of principle were very clear, as compared to a situation such as Article 5 of the OECD, where there was really no jurisprudence to guide you on how the thing ought to be approached or what the meaning might be.
Which you say is our case.
Which I say is our case. And as I say, I'm not going to go back through all the detail of Heathrow. We've dealt with it in some detail in the skeleton. We dealt with it in some considerable detail below. It effectively affirms the tenability standard in principle, but says you can look at the factors when you're considering standard of review, and if you have the sort of features that I've just identified, then that leads to a less intrusive approach. And if you don't, as there, because you had GATT and lots of jurisprudence and it was clear what it meant and so on, then there's much less difficulty. So I think, and I say so, we both respectfully regard Heathrow Airport as something of a curate's egg. By both of us, I mean both myself and the other side in relation to this argument. But the real direction, I submit, is taking the factors that were identified as particularly important by the House of Lords in Corner House and in the subsequent cases that directly address this issue. So that's the seventh position. The eighth proposition, my Lord Master of the Rolls will be delighted to hear, is even shorter than the fourth one, which is, and it's a point I've already made, so I simply repeat it, which is that we are, or there is a distinction, potentially at least, between the interpretation of an international, unincorporated international treaty provision and the application of that, the working through of what it means in the particular circumstances. So you've got a meaning thing and an application thing. And ordinarily, under public law, application would plainly be for the government, would plainly be for the executive, subject only to rationality control. And that is perhaps another reason why it's so as to support the tenability standard. You'll remember 125 in Friends of the Earth, the Supreme Court, reference to rationality there. But it would be strange, at least, if you had a different approach to the two. And the only way of trying to justify the difference is by saying, or by categorising interpretation as though it raised error of law which is correctable. So you're back to that. But I respectfully submit that can't be the right answer.
Unless a proportionality issue arises.
Unless a proportionality issue arises under well recognised, but
yeah,
we're not in that territory either.
No.
Massively. Yeah, my Lord will need no introduction to that under EU law on Lumsden or ECHR under well-travelled principles there. But attempts have been made in the past, as again you'll be very well aware, to bring in rationality as part of common law control, and they were, if I can put it this way, firmly squashed in a case called KU after a bit of floating of the idea by Lord Manson Pham, I think it was. So we're not dealing with that situation, but a bit careful here because there is, as it were, a merging of the question. When they say, well, the problem here is the rationality of or irrationality of the conclusion that supporting the measure would align with Paris. I'm not doing any definitional things at the moment, but to take that as a summary, there's a bit of interpretation of Paris Agreement, and there's a bit of application to the particular circumstance we've got here, and plainly in relation to the latter, the standard would be a rationality standard. So my submission is that the judgment of Lord Justice Stuart-Smith at paragraph 119 correctly identified the various strands in play, and did so, although I have put forward to my lords today a structure of the analysis with a particular focus on the constitutional issues to which it gives rise, and a development of the case law from Launder, as you've seen, in response to the arguments that have been made. But we do essentially submit that the Lord Justice Stuart-Smith approach, applying tenability ultimately, was the correct one. So the question then, that's the argument of principle, the question then is how that applies to the Paris Agreement, and by how that applies to the Paris Agreement I mean how do the sort of factors that I've just identified as part of the seventh submission, the various things that the courts have considered to bear on this issue, how do they apply in the context of the Paris Agreement? And I do submit, if you just take up the judgment below for a moment, if you would, that the nature of the analysis that Lord Justice Stuart-Smith conducted was not simply correctly, as I say, to identify some headline approaches and principles in 119, having gone through all of the relevant case law that we've now been through again. But what he then does is to say, applying these principles, I take the tenable view approach, on the basis that those factors will help him decide whether he's in one camp or the other, and what the standard should be. And he said tenable view. He doesn't just state tenable view, he states that it's tenable view because of the four factors that he then identifies and analyses between 121 and 124. And just to spin through them, I do respectfully submit that that is both compelling and entirely correct on the authority's analysis of whether we're in tenable view territory, or one could even remotely be in Launder type territory. And just to pick up a couple of points in relation to those paragraphs, I mean, the first point is that the provisions, as the judge finds in 121 and 122 of this analysis, the provisions of Paris are indeed aspirational, high-level, political end of the spectrum. They are not hard-edged rules. The application to the facts in any particular circumstance requires exercises of judgment, and all those points in 121 and 122 are, we respectfully submit, self-evidently correct. Secondly, there is no body of extensive jurisprudence on the Paris Agreement, entirely unlike ECHR, Launder, Kebeline, or GATT, Heathrow Airport. Thirdly, the provisions of the Paris Agreement anticipate that interpretive or compliance disputes would be resolved by negotiation and consensus on the international plane. See Articles 14 and 15. Fourthly, we also note that, or submit, that the Court is squarely in the territory of particular caution on the Court's ruling on issues of interpretation of this kind. There are no doubt a series of issues arising on the international plane relating to the Paris Agreement. One need perhaps only think from that perspective of the fact that there are a significant number of other signatories to the Convention who are strongly supporting, in the same way that the United Kingdom is, this project. More generally, there may well be a series of what might be described as foreign relations type issues in relation to the meaning, and perhaps the meaning in any particular context, of Article 2 of Paris, and certainly in relation to the question whether or not the combination of articles my learned friends relies upon does indeed lead to a hard-edged obligation on all signatories to the Convention, all developed country signatories to the Convention, not to support fossil fuel development of any description in a developing country unless it is in effect, I summarise, net zero or better. That is a highly controversial issue which might well have serious repercussions on the international plane for the positions that Her Majesty's government might wish to take on all sorts of issues. And you will note in that respect also that the United Kingdom has, under constant consideration, I'll come back to it probably tomorrow now in relation to the policies, but it has under, and has for years had under, active consideration how to deal with the Paris Agreement objectives and how to take forward the common goal of seeking to reduce emissions and so on. But that is not a binary subject. It's about as far away from a binary subject as you could possibly imagine. It's a multifaceted set of decisions involving a myriad of different ways in which that could be done and a myriad of different and major interests on the international plane. That's the first topic. Tenability standard applies is the submission in relation to Paris. It applies in principle and it applies when you apply the factors to Paris. I was going to turn then to the compatibility with the United Kingdom obligations under the Paris Agreement, that set of issues. And I wanted to start, and probably the last topic for today, as it were, but I wanted to start that before I come then to directly to the interpretation of Article 2.1c and the question of the rationality of the judgments about application or alignment. I wanted to start, if I may, with four initial framing points that go to this issue, or that bear on this issue. Firstly, there is a need, I submit, to place the focus of this challenge within its proper context of decision-making. And the decision-making here involved, as you've seen, a combination of the Secretaries of State and who are involved, including the Prime Minister and UKEF, to provide support. That process and how it all worked, and technically I think you have the position in your head that decision itself technically is UKEFs. They need, as a matter of law, the prior approval of the Treasury. They didn't need, as a matter of the legislative provisions, the prior approval of the Secretary of State for international trade, but she was concerned that she should be consulted and she wanted to say. So that was a factual thing, but that matters perhaps less. Place it in its proper context. It's a subject covered extensively by the statement of Mr. Taylor, who was the Chief Executive Officer of UKEF, and that statement is at tab 60 in the supplemental bundle, and there's also a statement by Mr. Griffin for UKF as well, and that's at tab 61 in the bundle. And if you had a moment to read, you may not have a moment to reread overnight, but if I was going to invite you to read any three documents, it would be those two statements again, and the, I'm sure I know you've read it all lots and lots, but and the climate change report, which is behind tab 35 in that same bundle. So the processes internally and within the government of decision making are described in Mr. Taylor's statement at paragraphs 25 to 44, especially 35 to 44. And they include, as I've said, various secretaries of state, formerly the Chancellor, and by way of submission, and number 10, noting that number 10 wanted some offsetting work undertaken, that's the right way of describing it, by Diffid and Bayes, illustrating perhaps the complexity and balances feeding into the decision making. But more importantly, what that section illustrates, and what the paragraphs that then follow illustrate in Mr. Taylor's statement, is that a whole range of considerations were in fact taken into account in the decision. They included the increase in exports for the United Kingdom, which is of course the raison d'etre of UKEF. The transformational effect on Mozambique, which I will return to, which meant that there was strong support from the host country, which regarded this project as being critical in economic terms to inter alia the provision of infrastructure that might enable it to move to renewables and all the rest of it. Strong support from the African Development Bank, see paragraph 67 to 68 of Mr. Taylor's statement. Strong support from the World Development Bank, see the same paragraphs. Strong support from the High Commissioner, Her Majesty's High Commissioner to Mozambique. And as Mr. Taylor puts it at paragraph 60, it was a project potentially providing the means to lift millions out of poverty. That, I think, is not necessarily his original phraseology. He's taken it, I think, from a World Development Bank analysis. The reference to that World Development Bank analysis I will bump into at some point when I come to the Mozambique position in a second. So transformational for Mozambique, strong and common views that the project, including through the economic benefits it would bring, could be an important contributor both to the transition in line with Mozambique's NDC's, nationally determined contributions, paragraph 62 of Taylor, from more heavily polluting coal and oil, which they were currently using, and a series of revenue, a chunk of revenue, strong chunk of revenue provided to fund new renewables project, paragraph 65 of Mr. Taylor. And then I mentioned the High Commissioner being concerned to maintain UK influence, including in steering the climate change agenda in Mozambique, paragraph 66 of Mr. Taylor. As part of that consideration, climate change and the Paris Agreement were considered. See para 69 of Mr. Taylor. But as he emphasises, it was no part of any policy and no part of the decision making to ensure compliance with the Paris Agreement. That's his statement at paragraphs 24, 77, 85 and 88 to 89.
24, 77.
85 and 88 to 89, evidence which was specifically accepted by Lord Justice Stuart-Smith at paragraph 216 in the judgment. So climate change and the Paris Agreement were considerations taken into account in the round, along with many other matters. That's the first point about placing it in the proper context. Secondly,
well, I just, I mean, if that's the case, since he's the decision maker, if we look at your skeleton in paragraph 1, which a lot of reliance was placed on, it says the UK Export Finance judged that its decision was consistent with those obligations. Where's the evidence of that then in that statement?
well, Lord, I think that's principally in the CCR and the statements I'm going to come to under the submissions.
The CCR is not a decision maker.
No, it isn't. But
And he says it was a key consideration. I mean, I'm just reading the paragraph, I think the central paragraph. It's important to note, 88, that although the CCR was novel and was a key consideration, it did not and was not intended to dictate a conclusion, nor was it intended to answer beyond doubt any questions about the likely impact of the project. Rather, it was intended to pull together information. There was no policy, and there continues to be no policy, which made the decision to support, subject to the outcome of the consideration of climate impacts or consistency with Paris Agreement. Now, I mean, is that consistent with that him having judged that its decision or his decision was consistent with those obligations?
Yes, because he takes it into account and considers it in a broad sense. The point that's being made there is that there are lots of other factors that feed into this, and there is no requirement as a matter of policy. There was no requirement as a matter of policy that said you have to be compliant with the Paris Agreement or you can't make this decision.
Look, I get all that, but what I'm concerned about is that I don't see the evidence, I don't see why the government's submission here is that there was a hard-edged decision, that the decision it was taking to fund this project was consistent with the UK's international law obligations under the Paris Agreement. Now, Ms. Seymour says, and she says it several times, you're on that hook because you've said it in this, you've said it in your statement of grounds and facts, and although there's nothing in the documentation that makes that a very clear fact, you are making that submission on behalf of the government, so it must be true, right? That's what she says. Now, what I need to know is it the case, or is it the case, rather, that there was no such decision, that it was consistent with those obligations? It was just one of a number of factors, and the CCR report, which I've read and do have in mind, said on the one hand and on the other hand, and raised a lot of very valid arguments on both sides of the debate. So, which is it? I mean, you may want to think about it.
I will think about it overnight again, and I've got a separate topic on that because I know that's a subject of concern to the court. But my respectful submission, it can be, as it were, both. I mean, the point that, just take the point in stages. There is no requirement as a precondition, whether it's policy or otherwise. There is no requirement for a project to be in alignment with Paris.
No, but
before approval can be given.
I understand.
1, 2. Nevertheless, the government plainly did decide to take into account and to consider climate impact and Paris. They weren't unaware of Paris, that's why they were doing the CCR. 3, and again I foreshadow, I'll come to the detail of this tomorrow perhaps, but 3, the judgment that was made on the evidence, principally the CCR and the evidence of Mr. Taylor, was a much more, if I can put it this way, loose and fluid and multifaceted thing than my learned friend would suggest. Well, the furthest that the evidence goes, if you still have Mr. Taylor's paragraphs that you were reciting a minute ago to hand, the furthest that Mr. Taylor goes in the evidence, in paragraph 90 and 91, is to summarise the CCR as judging that the project was, quote, overall in alignment with the Paris Agreement in particular. And then he sets out the various things that the CCR, or he summarises the various things that the CCR did and didn't do, and then says at the beginning of 91, these judgments were in line with the high-level aims set out in the Paris Agreement. I therefore was satisfied that in undertaking the CCR, UKF had considered the likely climate change impact of the project and had considered alignment with the Paris Agreement as was reasonable for the purposes of informing the decision. I accepted the CCR when making my decision. So he very much puts it on the basis that, I mean, he's not the expert, he's got some expertise, but he's putting it on the basis of the CCR. And that is, I respectfully submit, standing back from him trying to be realistic about it, that's what ultimately feeds through into the Secretary of State's submissions. Because the principal one, which went to the Secretary of State for DIT, I think, which we'll come to tomorrow, enclosed it and recommended a decent read of it by the Secretary of State on the CCR.
I wonder, and it may be quite wrong, whether you are submitting in effect that the situation here was parallel to the situation in the third runway case. In the passage you showed us, where you sought to emphasise, as I understood it, that the Paris Agreement was considered, but not, as it were, taken into account as a material consideration bearing on the decision that had to be taken into account under the Act. That there were two things which needed to be differentiated there. I'm wondering, and I don't want to impose this point on you, but I'm just wondering whether really what you're now submitting to us is something close to that.
Which goes, I don't want to overreach on the point.
No.
And I want to try and present the evidence in a fair manner. I mean, it's evident that they considered it.
Yes.
And it's evident that they thought pretty hard about it, and by it I mean Paris.
Yes.
Because they did the CCR report, they went out of their way to do it, they tried to work out these things, there's quite a lot of detail in there, they went to an expert firm called Wood Mackenzie and got them to do lots of work. And so they plainly did consider that. It was plainly relevant to the consideration. I'm not sure I can go quite as far as to say it wasn't material. I think the point that's being made by Mr. Taylor is it wasn't critical. And as it wasn't critical, as the same point that was being made by Lord Justice Stuart-Smith, as it wasn't critical, then there wasn't a need, as it were, to reach a binary answer. They could say, well, look, we look at that. There are obvious issues under Paris. There are obvious issues in relation to climate change impact, very many of which we simply are incapable of reaching a sensible, considered, final or definitive view. So I suspect that the fairer presentation is perhaps not to take the stand on materiality, because that's very often relevance, and it plainly was considered in that sense, but to recognise that as it wasn't critical, there wasn't, as it were, the same need that you would have to reach a clear and finite and definitive answer to the question, what does it require, how does it work, what are the answers to the thing on all the evidence, and how do we weigh them up and how do we deal with it?
Well,
Yes.
it won't surprise you to know that I have concerns about the tightrope on which you are now positioned. I would suggest right in the middle, because I don't see the consistency between what you've just said and the various paragraphs in Mr. Taylor. I'll read it again overnight in its complete form, and we can look at it again tomorrow. But my concern is only because of the point I put to you earlier, to which you will come, no doubt, tomorrow, which is that on one analysis, the government did decide on this day that this project was consistent with the Paris Agreement, and then said something quite different the following day in the, I can't remember the initials because they're all roughly the same, but the Commonwealth something report. And then, of course, it transmutes, and we've seen some information as to how it transmutes into the December and then the March policies thereafter.
Well, I'll certainly, my lord, sorry.
I know you're going to come
Yes,
to that.
and maybe just to say, I mean, I will certainly address that issue on the premise that, as it were, they do consider it and they do reach a conclusion.
Well, of course they do, and they did. And the question is it consistent? And was there any different evidence or reason for the decision that led the one hand of government on the 30th of June to judge that its decision was consistent with the obligations in the Paris Agreement, see your skeleton, and then to conclude the next day and thereafter such a project would not be. Now that is the concern I have, you know that, and I think we'll, with that happy note, adjourn at 17 minutes past 4 until 10:30 tomorrow, unless anybody tells me it's absolutely imperative we start earlier.
No, my lord, but may I just when you're looking at Mr. Taylor's statement, if I can draw your attention specifically to paragraph 134, where he says that I've seen an advanced draft of the defendant's detailed grounds of defence and can confirm that I believe the facts and matters set out in that document to be true. Now, the normal position in public judicial review is that the grounds also stand as evidence, but there we also have that signed in a witness statement. So the paragraphs to which I took you essentially stand as evidence.
Great.